specific acts were all about. I mean, it really seems like you had 7 instances, if I recall in the brief, of specific acts that you wanted the jury to hear about, and the judge said no. And it strikes me that this trial would have been a lot more protracted if you start getting into little mini trials about these specific acts.
Well, I don't think that was the concern of the trial judge. I think the judge, the judge was concerned, and at the end of the case he said, had the jury heard this, the defendant would have been acquitted. He wanted the appellate court to know that he was having some second thoughts about his ruling.
But we have to be concerned what we put in an opinion, because that's what trial judges and lawyers are going to run with in the future. So again, my question still stands. How do we, if we accept what you say and say, yeah, that's what the law is, I'm concerned about how we craft an opinion so that trial judges,
Well, in this particular case, the way you craft the opinion is because Gary Czeskowski is an exceptionally rare and unusual individual. And without the evidence of Mr. Czeskowski's many other specific acts of generosity, the state can make their argument that these gifts can be only for the purpose of influencing public employees. But when the state keeps out the evidence that the defendant gives gifts to everyone, frequently, generously, to strangers even, in an exceedingly generous, unusual way, rare, very rare and unusual, then the state can argue, as they did in closing, well, Mr. Czeskowski wasn't running a charity, he was running a business. They said that 3 times.
Can we go back to your as-applied argument?
Yes,
the
sir.
state, in their answer brief, relies on Hoberman versus State. It's a Florida Supreme Court case from 1981.
Yes.
For the proposition that the unlawful compensation statute conveys, quote, from the case, a sufficiently definite warning as to the prescribed conduct, unquote. I didn't see in your reply brief any comment on the Hoberman case. What's your response?
I acknowledge that is what Hoberman says. That is all that Hoberman says. It doesn't give any, does not explain, well, what does not authorized by law mean? And whatever it means, it certainly does not mean what the state had the judge instruct the jury in this case, that a gift is not authorized by law if a public employee exercising reasonable care would believe that it wasn't a lawful gift, that it was given to influence. And that gives a standard of not what the actual intent of this public employee and this payor were, but what is a possible, a reasonable person wouldn't think that was a valid gift. And that is specifically what this court says in Talabesco. It's when it says you have to look at the actual actor on page 576, towards the end, when you start talking about all of these definitions, and you say that the jury can decide what the intent is based on the actions and the words of the giver and the payor and the official. And this is not what was instructed on in this case. The judge gave the jury a construction that it's not in Hoberman, this construction. It's nowhere in the case law, this instruction that the judge gave.
It came from a statute, 112.3134.
It did. It came from 112.134, and the defendant objected to that and wanted the second part of 112.3132 given, because that subsection makes it clear that there has to be an exchange. There has to be an understanding that you want some official action, vote, or judgment of the public officer would be influenced. And so that is what prohibits it from being applied to a mere conflict of interest situation.
I understand that the state, in the response to the defense's motion for judgment of acquittal, made this argument about what would a reasonable public employee think.
Yes.
And at some point during the trial to the jury made that argument. But ultimately what the judge instructed was not what the state was saying. And it's not one of your grounds for appeal what the state was saying, although I know you threw it into the brief as part of your argument. What you're arguing is that the instruction was incorrect on 112.313, but the statute says, or any compensation, payment, or thing of value when such public officer or employee knows. So I'm just wondering why you need the language out of the Barker, D'Alembert cases as was the defense attempted to do, to throw that additional language about it's not a hypothetical public official, it's not a reasonable public official, it's what this public official, when the statute itself says such public officer or employee knows. Why isn't that good enough?
Because immediately after what such public employee knows, it says, or with the exercise of reasonable care should know, and that is the portion of the instruction that the state relied on. The state couldn't rely on that the employee knew it was given to influence because it wasn't given to influence.
But there's a difference between what a reasonable public official would think
Yes.
versus what this public official ought to know in the exercise of reasonable care, what he ought to know in the exercise of reason. Those are two different concepts.
Those are two different concepts, and that whole part about, okay, wait a minute. Back, the Florida Supreme Court, back in the Laughlin versus Pridgeon case, that was a 1947 case. In that case, they found a statute unconstitutional where it said that it is unlawful for a public employee to commit any act, quote, not authorized by law. And they found that was too vague. There's several cases that we've relied on where the Florida Supreme Court has found not authorized by law too vague when the state was having to refer to something else to define what is illegal or improper. In this case, it's not referenced in the information. It's not referenced in the statute in 838.016 that, oh, you're going to go to this civil statute on ethical behavior of public employees to find out the definition for what is a permissible gift. And these definitions under 112.313, subsection 4 is not enough. Subsection 4 is not enough. If they were going to give that, which the defendant in the first instance, way back in the first trial that Mr. Czeskowski had, where he was acquitted, they gave both of these subsections. And the state said in answer to the motion to dismiss, well, this statute isn't unconstitutional when we're going to instruct like we did in the Palm Beach case. And we're going to give these two subsections of 112.313, subsection 2 and 4. And so, you know, if you have to look to some other part of the law that doesn't, and that's the thing about it, doesn't say, like in Rodriguez, within the law itself that you look to 112. They came up with this, and then the state said, no, we don't need both of those subsections. We only need subsection 4. And the defendant said, well, I want subsection 2. And he does have to, the judge did have to give a reasonable jury instruction based on that this isn't about some hypothetical person, like what a reasonable person would think. This has to be the actual employee. And I do not think that subsection 4, standing alone, gives that intent to the jury and makes it specific what is authorized by law or not authorized by law.
The argument, though, is almost like stating the negative to the jury. It's very similar to your good faith argument, saying that there should have been a separate argument that good faith is a defense. I don't understand what the judge ended up doing, saying it has to be with corrupt intent and not good faith. Again, it seems almost like a given that corrupt intent can't be in good faith. It doesn't seem really necessary, but it was given. So to say, as the defense proposed here, it's not a reasonable public official and it's not a hypothetical public official, it's this person. Again,
Yes.
the language, if the language is there, why do you need to say the converse to prove the point to the jury?
Because of the interpretation that the state gave. And also, while you've touched on the good faith instruction, I will just say that what the judge said as an opposite, corruptly given, not in good faith, does not define what good faith is. And the defendant was very specific as to what he wanted. He wanted that it was an opinion honestly held in the absence of ill will that you're acting lawfully. And I believe that all of the evidence in this case was that was Mr. Czeskowski's belief, that was the belief of the public municipal employees and also of the sales people that gave the gifts.
Am I correct in understanding that the seven specific instances that you wanted the jury to hear about, all of those were expenditures out of his personal funds and not out of the corporate funds?
I don't believe that that was specified in the evidence.
Well, you rely a lot on Beal and Bogren, and,
Yes.
and the point the state makes in answer to that is that Beal and Bogren are theft cases, and the court said it was improper to keep the specific acts out because it involved the actual property that was taken, and that's not the situation you have here. And it does strike me, because the argument you wanted to make to the jury, if I'm processing correctly, is my client's a good guy and he's a generous guy, and I have all these examples. The problem is, if I understand it, they're from his personal funds and not from the business funds. And I just question if the idea of character evidence is he's going to act consistently. What people do with their personal money frequently is very different than what they do with their business money. So I'm concerned that Beal and Bogren really don't apply because, again, we're talking about expenditures that came from personal money as opposed to business money.
Well, Judge, I don't believe, I have a concern as to where you got that consideration. I know the
What consideration?
well, your consideration, you said, is this your personal versus business? Because I don't know, the state did not question that on the proffers. Were these gifts that you gave out of your personal funds or out of the Chaz business funds? So you're making a distinction now that is nowhere developed in the record. It was not said. I mean, if that's the distinction you're going to hang your hat on, that has to be something that's in the record. And it's not in the record that all of these acts of generosity were from his personal funds versus his business funds.
Let me attempt to rephrase the question this way. These other gifts that were given, for example, to the family at the school,
Yes.
or to the family that he saw on the television,
Yes.
or they fell out in Texas. There's a distinction to be made between, it's almost like the person down in Fort Lauderdale who got very involved with a lot of charities and was always being shown with politicians and sports heroes, but he's running a Ponzi scheme. In other words, you clothe yourself with the appearance of goodness so that when you're doing the bad things, people maybe look the other way. I mean, is there a suggestion that we ought to keep out stuff you're doing for personal people and let's just stay focused on your business? In fact, didn't the trial judge in this case allow one specific act of generosity as it related to someone I think named Jones, one of the public employees? They got to present that evidence of that specific act of generosity?
The only specific act that they were allowed to mention was Jimmy Hartman. His cat was very sick, and the Chaz salesman came to Gary. There was also some suggestion taking advantage of his generosity and asked, "Will you pay for this $900 vet bill?" That was the only one that was admitted. I'd like to save the remainder of my time.
I'll give you a couple of minutes. Mr. Hamill, you may proceed.
May it please the court, Mark Hamill for the state of Florida. Here's the evidence that the jury heard about the defendant's reputation. 6 witnesses got up in front of the jury and talked about his reputation for generosity. One of the witnesses said, "I've never known anyone more generous." Another one said, "He's like Santa Claus year-round." And then, as was just discussed, it was Bradley Miller testified to the specific instance. He testified that appellant paid the vet bill after James Hartman, who was a field supervisor for the Palm Beach County City Water Utilities, after the cat died. So there was a good amount of evidence that came in about appellant's generosity, and I think the trial judge bent over backwards letting it in. This did not have to do, all this reputation testimony did not have to do with the same context that was being charged. It didn't deal with him giving money to municipal employees. And for that reason, the judge said, "I'm going to let that in, only reputation." and specific instance when it comes down to the same context. And that's what the rule of
Don't I
evidence provides.
remember that in closing argument, the state made some comment about telling the jury it's important to recognize that these gifts came from a company and not from him personally. So was there any evidence as to whether or not these other acts of generosity, or his generosity was sometimes personal money as opposed to business money? Was there anything put before the jury on any of that?
Your Honor, for the charged conduct, there was some talk about that, about whether the money was paid by him personally or from the company funds, and he was like, I own the company. So he kind of equated the money of the company as to his money, and I know the prosecutor said, well, you're a 70% owner of the company, and his response was, I'm a 75% owner of the company. So there was a little bit of going back and forth about how much he owned the company, and that money was company funds used to pay. As for the proffers, I do not recall. One additional thing I'd like to mention, though, when these witnesses got up and provided that reputation testimony and said he's a very generous man, what the state did after that on cross-examination was they got up and they said, do you know anything about him giving money to municipal employees? And they were like, no. So this testimony had very little to do with the charged conduct, which was how he conducted himself when giving money to municipal employees and whether the intent was to get something in return or not.
Was there any evidence, I'm sorry, was there any evidence of that? Did other employees testify that he suggested that by giving these gifts, it was good for business, or
Absolutely, and
what
that
testimony was that?
that
Or
kind of
whatever?
relates to point 2. And that was, it had to do with bringing, I don't have the page in front of me, I know it's in my brief. It had to do with when they brought some municipal officers to a NASCAR race, and as they were walking away, the appellant said to him, the reason why we do this is so that they'll remember us at the time of the next PO, which is a purchase order, meaning when they're looking for a contractor to give business to. So that was a specific evidence there. And circumstantial evidence came from how he acted about the watch, how he gave the watch and then told his employees to lie, and then even fired one employee for not going along with his lie.
The rule on specific instances of conduct, 9405 sub 2, says, when character or a trait of character of a person is an essential element of a charged claim or defense, proof may be made of specific instances of that person's conduct. I understand the defense's position. Their defense is he's a generous man, and generosity is a trait of a character of a person. So I guess the key phrase is that what comes in the middle is an essential element. Again, the rule says a trait or character of a person is an essential element of a defense. Why isn't generosity, that being a trait of character, an essential element of the defense of I'm a generous person?
For one thing, you have to look at the same context. We're talking about a different context when it's not related to municipal employees. And he certainly can give generously to municipal employees. He can have dual motives. He can, on the one hand, want to influence their decision-making, and he could like the person and want to give him a very expensive watch. And that appears to be what happened, at least as far as the watch goes. But just because he's generous, you can't make the leap of logic that he couldn't give a bribe because he's a generous man. It just doesn't follow. I mean,
But the rule says it has to be an element, not the only element or the
Right.
complete element. So they're trying to say that to prove our defense, we have to at least show to start with, he's generous.
essential element, I think, is what it says, Your Honor.
Correct.
Okay, so it's not essential that he be generous. It's just, it could be a trait of his character. He could be nice to animals. He could be interested in the environment. He still could commit crimes. And that doesn't mean, just because he's generous, doesn't mean he essentially couldn't have committed the crime. It's not something essential to their defense.
So your point is Robin Hood was a very generous guy, but he was still a thief.
Yes, Your Honor. And the other point is, what enabled him to be so generous is the fact that his company was generating so much money.
Right. So I'm puzzled because if I understand it correctly, the watch was the most expensive gift. right? Over $10,000 or something?
8,000, yes, Your Honor.
8,000, okay. It was clearly the most expensive, if I recall correctly.
I believe you're correct, Your Honor.
But yet, he was not charged with a count involving the watch. And is there something in the record that explains that?
I believe-
Because most of the counts, if I recall, are on a principal theory. I mean, he wasn't actually one that gave the gift card. He's not the one that actually, gave the travel arrangements or whatever. All the counts were pretty much on a principal theory against him, correct? So I'm puzzled about why he's left out of the watch.
Your Honor, I thought he was charged with the watch, but I'm going over the counts here. I have them notated, and I think you are correct. I don't see the watch here listed. And I do not know the answer to that.
Well, because the defense made a big point of that in closing argument. He's not charged with a watch, And if the whole idea he's supposed to be so corrupt, why didn't they charge him with the watch? Was one of the arguments they made in closing, if I recall. So I quite frankly assumed he was, having read the briefs, and then I thought, really? So, there's nothing in the record that explains that then.
Off the top of my head right now, I don't know, Your Honor.
Okay.
Could you turn to the defense's as-applied argument? They make the point that the state's prosecutor, at various times during the trial, to the judge and to the jury, argued that the standard of not authorized by law depends on what a reasonable public official would think. That's clearly not the law. It's not what 838-016 provides. It's not what 112-313 sub 4 provides. I understand it's not a specific point on their appeal. Their appeal is based on how the instructions were ultimately laid out, that it was unclear to the jury. But I'm concerned about the improper argument being made to the judge and the jury at various times.
Your Honor, I did not address that. The way they worked that into their argument was, this is what shows that the statute was unconstitutional as applied. My focus is on what the jury was informed of, what the instructions were given. I do know that they were saying the prosecutor's theory changed versus a co-defendant, and I did notice that after this court rendered a decision, the co-defendant reversed the co-defendant's case. There were concerns raised during the oral argument of that case, and this court's oral argument transcript was furnished to the trial court, and some of the concerns voiced by this court were responded to in this trial. And now they're using that as an example of how it prejudiced their client.
Let's just confine ourselves to this trial. During this trial, this state attorney made an argument that is inconsistent with two statutes and two Florida Supreme Court cases. So how do we deal with that situation?
Well, you deal with that because it's not a point raised on appeal, and you're talking about closing argument or an argument to the court on what instruction?
It occurred in response to the motion for JOA, and it occurred to the jury during closing.
Okay, if there was any error in the instruction given to the jury, the jury was told that the law will come from the court and not from the attorneys, and also his attorney had a chance to respond to that. And off the top of my...
I don't think it was objected to when it occurred during closing, but nevertheless, it's still, their argument is, again, this as-applied argument, which almost takes you beyond the necessity of an objection during closing.
I understand their argument to be based on the instruction that was given. Now, if there was a comment not preserved, I guess I could brief that further. I did not look closely at that because my focus was on the crux of their argument.
I understand.
So the best I could say to that is what's really important is the instruction that was given to the jury, and if no objection was made, maybe it was remedied when defense counsel got up and argued.
I'd like to ask you about a topic that didn't come up during an oral argument, but obviously was briefed, having to do with the 10th Amendment information being inconsistent with the ultimate jury instruction. I understand the state's position was, well, we cited 838-016. They could have read it and could have cited the defect in the information. But if you think about it, the information itself just didn't track the crime. It didn't provide either option, whether he believed it or whether the public official represented it. It just simply said it was within the official's discretion. What's your response?
Defect in the information is waived if no timely objection is made. And they waited to the wrong point in time, and it's kind of like a gotcha tactic to say now, oh, there was something not in the information, which there's no claim that they were misled in any way. The way the information, the language was included, it did not track the statute. It just said a violation of any act or omission within the official's discretion. And the statute does not require that it be within the official's discretion. It's either that the giver believed it to be within his discretion, or the receiver represented that it was within his discretion. So whether it was actually within his discretion didn't matter, but in this case, there was testimony on all the counts that the people who received this money had the discretion to give business to this company or not, to make those kind of decisions. So it was not really contested in this case. It was not a point of contention where they would have been prejudiced by this incorrect information in the information, the incorrect language. And I think their failure to object also illustrates that they weren't prejudiced by it at all. He knew exactly what he was charged with. I think there were 10 or 20 amended informations in this case. And if there's no further questions, I'd ask you.
Give me a sec.
Sure.
Yeah, 10 pages of notes. Oh, on the statement that was allowed in from the employee, it says, well, we were coming back from Daytona from the NASCAR event, and the defendant said to me, well, hopefully this will be remembered in the future. And it appears from the record that this statement may have been made back in as early as 2005, 3 years before the events that were ultimately charged. I understand what ultimately happened here was it was allowed into evidence without giving reference to the year.
Correct, Your Honor.
But putting aside the statute of limitations argument that the defense is saying that this is somehow bringing up a crime, and the jury doesn't really know about it, my bigger concern is we don't know what his intent was 3 years later when these other acts are occurring. He may have thought in 2005 this is the way to do business, lavish gifts on people so they remember us later. But to say that that's going to establish his mindset for crimes that occurred 3 years later there's a stretch to be made there. Explain that to me.
Well, this was the employee who was hired to be a sales associate for the company. So he started working, may have been 2003, 2005. And when he was brought into the company, there was some testimony he was a great salesman. And appellant trained him on how he wanted things conducted with his company. So this was part of that, and most of these charges are, he's being charged as a principal because he didn't give the money. The money was actually given by this salesman. So this established this salesman's background, being trained by the appellant on what he was going to do and what was expected by giving money to these employees, by going to NASCAR races and stuff like that with them. So this just provided background, and that employee certainly could have been cross-examined and asked, when did he make this statement? Did he come to you after that and tell you, no, we're going to do business differently from now on? This employee testified that this is how he did business, giving out these gift cards and being generous to these municipal employees, and it all came back from the way the appellant told him he wanted to conduct his business, how he wanted his company officers to operate. So that's how it was tied in. It wasn't so much something he did 1 year and then 5 years later he did something else. It was something he said, and then years later it was what his employee did based on what he was told years earlier.
Last question for me on this good faith argument. You made the argument that it wasn't preserved because they never got a ruling on it from the judge saying, I reject that, good faith is complete defense, special instruction. And in fact, the next day they come and say, well, we'll agree to the corrupt intent and not in good faith. But at one point the judge said to him, I don't like the defendant's good faith instruction. I think I may be paraphrasing, but he basically expressed his negativity. Why can't the defense at that point accept that as, or believe they have a ruling at that point that when the judge says, I don't like it, Judge isn't gonna give it, and that preserves it.
I think you actually need to get, not just say, I object to it, but tell the judge why he's wrong and provide the judge with an argument or maybe legal authority for why he's wrong. It's all about, they're there to assist the judge in getting the instructions right. And if the judge says something expressing disapproval, you're not helping the judge out by just remaining quiet, like you have no problem with the course the judge is taking. If there's something wrong, defense counsel really should speak up and say, no, Your Honor, that's really wrong based on this case, and therefore this instruction should be given. So for that reason, I don't think it was properly preserved.
Okay, thank you, counsel.
I would like to remark that Mr. Hamill keeps talking about giving the gifts to give business to Chaz. And I believe, Judge Connor, in one of your first questions to me, you said he's giving gifts in hopes that you'll pick me. These municipal employees that were given these Christmas gifts and these by the salesman, they were not in a position to give business to Chaz Equipment Company.
But you're not seriously going to contend they didn't have, that surely the decision maker would talk to the people in the trenches, so to speak. What do you think about this company? Should we use them or not?
Yes, but the contract was already in place, and all these people said is whether the work is in the ground. Did they
Well, they're in
comply
place,
with
but-
the contract?
But my understanding is these things have to be renewed.
Yes.
And my understanding is there's this whole phenomenon of piggybacking. So obviously, these people that the gifts were given to might have some impact on all those processes.
But every single witness testified that Chaz Equipment was the best vendor that there was the best person to put this, to rehab these sewers. Everyone raved about their work, even people who were not directly related to the contracts, employees and supervisors in Palm Beach County. And these people only said the work was done, it was in the ground, they did a good job. They had just the whole way you're saying to give business and in hopes that you'll pick me, that's a mischaracterization of the evidence. That is not what these employees didn't have that kind of influence. I also want to say that in point 3, I did specifically argue that the jury instruction as given was the penultimate evidence that it was unconstitutional as applied when they gave an unconstitutional interpretation of the statute to the jury. And I do believe that that is the specific point on appeal, and it's specifically preserved. And I also, Mr. Hamill would not admit up here that the defendant being an exceptionally generous person was the defense. And Mr. Funk did admit that during the motion to dismiss. In the lower court, the judge questioned him. I have that interchange set out at page 17 of my brief. It's at page 34 in the trial transcript. And Mr. Funk says, yes, that would be their defense, that he is generous, that he is exceptionally generous. And
Is that a legal defense or a factual defense? The reason I ask that is, typically your legal defense is, yes, I did it, but I have an excuse. Here, you can't say, yes, I acted with corrupt intent, but I did so because I'm generous.
No.
Those two don't correspond.
well, they're inconsistent. His defense is, I gave the gifts. I gave the gifts with a clean heart, with a generous heart, because it made me feel good to give the gifts, because we give Christmas gifts at Christmas time, and that is inconsistent.
Well, I guess
with-
I'm not making my point clear. That's
Okay.
what makes it not a defense per se, as Judge Connor alluded to his Robin Hood example before. Robin Hood committed a crime, but he said, but I did it for good reasons. But he says, I committed the crime. When you say, his defense in this case was, I didn't act with corrupt intent. There
Right.
was no crime. So
Right.
so it doesn't make generosity a defense. In other words, he can't be found guilty of having corrupt intent and then have a defense of generosity. It's really not a true legal defense per se.
Well, we contend in these circumstances under 90.405, it is a legal defense, and that he was given a character instruction that the jury could find a reasonable doubt based on based on his good character, based on the Hudak case from this court, saying you're entitled to that instruction. And as to your question, Judge Connor, about where was it explained why Lombardi was not charged, the whole watch thing, it's about page 1300 of the transcript. During the charge conference is when they discuss that. And the state is objecting to the defense being able to argue, oh, they didn't even charge Lombardi or Mr. Chaskowski with the gift of the watch.
And what was the trial judge's ruling on that point?
The judge's ruling was, yes, the defense may argue that in closing. That's a fair inference from the evidence. You're allowed to do that. But the state, in arguing against that, explains, or tries to explain, not very well, I might add, why they didn't charge him with that.
Okay,
Thank you, counsel.
Thank-
All right, thank you, ladies and gentlemen. We're going to take a short recess. I wanted to welcome the